I'm Ian McLeod, Director of IMMagine Australia New Zealand. The Immigration Advisors Authority is approaching its 20th birthday, and I have to say I think it's failing in its duty and its legal responsibility to protect vulnerable migrants from those people who are giving immigration advice outside of New Zealand. Taking a step back in history, the original thinking of government was only those people giving immigration advice based in New Zealand would be required to secure a license under the proposed regime. People like me objected to that because we all knew, as did the government of the day, that most of the harm committed against migrants looking to move to New Zealand did not take place in New Zealand, but took place overseas. The government of the day agreed with that point, and the legislation was written to include all people on planet Earth giving immigration advice. All would need to be licensed, all the watchful eye of the Immigration Advisors Authority. But fast forward nearly 20 years, how's the IAA done with that, especially policing unlicensed offshore advisors? Well, the answer is pretty poorly. And a light has been shone on this point in Watson versus Huang, an INZ-driven complaint against a New Zealand-based advisor. The IAA threw the book at this guy, and I don't have any great qualms with its findings, although I do find some of it pretty picky and pedantic. But that isn't the point. In its own investigation, the IAA came up with some pretty compelling evidence that a recruiter that the immigration advisor had been working with had provided immigration advice to up to 130 people that the immigration advisor had processed visas for. So that's 130 people that the IAA provided evidence, or uncovered strong evidence, was almost certainly providing immigration advice. What did the IAA do about it? Nothing. It looked right past its own legislation and doesn't appear, certainly around a year later, to have taken any action against the third party. Now, it would argue it would be difficult to do so. They're overseas, there are jurisdictional issues, there's financial consequences and implications of pursuing these people. But the fact remains the Act of Parliament requires them to do it. They don't get to choose. And when harm is being done to people looking to come to New Zealand, and New Zealand's reputation is at threat, the IAA has an obligation to investigate, and where it needs to, lodge complaints and see these through the entire process. The message has to be sent. The Act is being taken seriously. Investigations that suggest impropriety will be punished. But the IAA has decided, at least in this case, and I'm sure there's many others, of not bothering to do anything about it. So as it approaches its 20-year anniversary, I would like to think the IAA will start doing its job properly and thoroughly, and taking on these big organizations overseas where its own investigations suggest that they are providing immigration advice, and doing something about it.